A grant is effectively a court order authorizing a person to handle the assets of a deceased person. According to Section 60J of Probate and Administration Ordinance, it is an offense if any person who without lawful authority or reasonable excuse deals with any part of the estate of a deceased person which is not set out in the schedule of property annexed to a grant made to an estate. The most common grants are Grant of Probate and Grant of Letter of Administration, but there are other grants that would be issued in special circumstances. If the deceased died with a will, the person named as executor should make the application. Otherwise, it's the deceased next of kin who should apply. In the event of intestacy, the following persons of the deceased have priority to apply for a grant under Rule 21 non-contentious probate rules: spouse, children, parents, and siblings. The significance of priority is that those who have subsequent right cannot apply for grant unless the persons who have prior rights are cleared off. A grant can be applied for at the probate registry of the High Court. The applicant must submit documents to support such an application. Applicant's affidavits: a schedule of assets and liabilities of the deceased, setting out all assets that are in the name of the deceased. Documents to show entitlement of the grant. Original will of the deceased. Public document to show relationship with the deceased, such as marriage certificate, birth certificate, or adoption certificate. Documents to show prior rights have been cleared off, such as death certificate, divorce order, or deed of enunciation, properly signed by those who have prior rights. All supporting documents must be certified true copies issued by the relevant authorities, such as Birth and Death Registry or Marriage Registry. All documents issued by foreign governments must be properly authenticated. It depends on the complexity of the case. For a straightforward grant of probate application, it can be issued within a few weeks. Otherwise, it might take even months. The court has an inquisitorial role in the application and accordingly may raise requisition when the application is processed. The executor or administrator is appointed by the court to administer the estate. They are under an obligation to administer the estate in the interest of the creditors and beneficiaries. They have a duty to faithfully administer the estate by calling in the assets, settling all the debts, and distribute the estate at the end of the administration. They should also keep a proper account of the estate and answer to reasonable inquiries made by the beneficiaries. One of the many functions of a will is to streamline the probate process. Without a will, the succession process becomes more complicated with the need of more supporting documents to be provided. And a longer process often means that the family cannot access the inheritance to meet their financial needs. So we cannot emphasize more the importance of making a will.